Hello, Colorado Realtors. I'm Scott Peterson, and thank you for joining me for another edition of Legal Bites. Today's a very special edition of Legal Bites because for the first time ever, I have a live studio audience in here. Guys, could I give it up here? It's a massive studio audience. There's like 4 or 5 of them back there, trust me. We are fortunate at the Carr offices today to have the Pikes Peak Association of Realtors Leadership Academy class for 2018 visiting the office and doing some classes and training here today, and so they have an opportunity. I don't know if opportunity is the right word. They have the burden of sitting in on a filming of Legal Bites, so it's nice to have them here in the office. On today's episode, we are going to be talking about how not to get paid, which is something that no broker really wants to talk about because you're all obviously interested in getting paid, as you should, for the hard work that you do. If you remember several months ago in an earlier edition of Legal Bites, I called it, it was entitled How to Get Paid, or How Do You Get Paid, I think is the exact title of the earlier episode of Legal Bites, and that had to do with commission agreements, of course, and listing agreements and theories of maybe procuring cause, the ways that you do get paid. This is going to be a little bit shorter edition because this is how you don't get paid, and I know not many people really want to talk about that, but it's important stuff to understand, and I'm surprised on the legal hotline the volume of calls, despite something that I think most brokers or most realtors understand, the volume of calls I continue to get related to how somebody can secure their right to payment with a listing agreement or something else. The Real Estate Commission rules in this regard are very, very, very explicit. It's governed by Rule E48, and they are prohibited. The Rule E48 is described as prohibited remedies for compensation. So these are things that you can't do in order to get paid. And clearly those are not filing any lien on a property, not filing any lis pendens, which is basically a notice that a property is going to be lien, or recording any of your listing contracts or other agreements. It's very easy to record something against a property. You can simply go down to the clerk and recorder, and they'll record just about anything against a property. But if you're a licensee and you're doing that, and you're doing anything whatsoever that can cloud title in relation to you receiving a commission, you can get into super big trouble with the Real Estate Commission. That's just exactly the kind of behavior that would absolutely get you in trouble. So this is for any residential brokerage duties pursuant to any written agreements or anything else. You don't have a right to do anything that would cloud the property's title, whether you're working on the buy side or whether you're working on the seller side, on the listing side of a transaction. Don't do anything whatsoever that would ever cloud a consumer's title. There is hopefully other recourse to recover commission payment, and that could be a suit for breach of contract. It could be an action through the Realtor Association, maybe through the offer to compensate or cooperate through the MLS. There's other ways to get compensated, and they're not always the best, or it could be more time-consuming than being paid at the closing table, but don't ever do or threaten to do anything that might cloud a consumer's title. There's one exception to this, and it applies in a very specific, narrow area. A few years ago, the Colorado Association of Realtors, our legislative folks, our government affairs folks, did quite a bit of work on something that's referred to as the broker lien law. So this comes out of 38-22.5-103 of the Colorado Revised Statutes, very narrowly focused on a specific area where a broker or a licensee or a realtor could record a lien against a property, and that is in a commercial transaction only. And as you're considering this, please understand commercial is very specifically defined, so make sure you're referencing, if you're ever contemplating recording a lien in relation to the broker lien law, that you are exclusively doing it on a commercial property as defined in the statute. It is only for leasing services, and so this would be in the event that you found a tenant, you brought a tenant to a property, or you procured a tenant on behalf of the landlord. And I think it'd really primarily be if you procured a tenant on behalf of the landlord, because one of the requirements of the broker lien law is that you have to have a written listing agreement with the owner of the property. There's got to be some written agreement that's in place. And if you have a written agreement and you don't get paid by a property owner on a commercial transaction for procuring a tenant, then you do have the ability to file a lien in the amount of up to the compensation that is provided for in the agreement itself. So pretty narrow area. It's a pretty important and useful area if you're a commercial broker primarily, and I don't know that it's fully utilized, the law is fully utilized as much as it really could or should be. It's always good to have written agreements in place, and you certainly have to have one with regard to the broker lien law. But even if you have one in any of the other areas that you might be performing your realtor functions or brokerage functions, you need to be very cautious and not record anything to secure your commission. Don't interfere with the closing of the transaction. Pursue additional remedies post-closing, because you always have to worry about the license law and regulatory discipline that may follow with doing anything like that. And it's a no-brainer. So as with this and any other topics, if you have questions, the hotline is available from 9 to 12, 1 to 4, Monday through Friday. We always love to have calls from our members. So thanks for tuning in for another edition of Legal Bites, and we'll see you next time.